Good day. Today we'll be looking at preliminary consideration before commencement of action. Firstly, we'll look at the definition of subject matter. We'll try to define the subject matter. And secondly, we'll look at those things to be considered by a legal practitioner before he institutes or commence an action in court. I am Ogunye Briggs Esquire. Now let's get down to business. Preliminary consideration before commencement of action in court are those factors that a legal practitioner must consider before instituting an action in court. And these factors include the following. Number one, cause of action. What then is cause of action? Cause of action simply means the aggregate of material facts that can lead to a party having a claim in a court of law. For an action to be instead in court, there must be a cause of action. That is one point that we are supposed to know. That there must be a cause of action before a legal practitioner goes to the court to institute an action. The second factor is local standard. Local standard helps to determine whether the claimant has sufficient interest in the matter. This can be found in Section 6 sub 6 sub B of the Constitution of the Federal Republic of Nigeria as amended. We should note that where a claimant lacks the requisite local standard, the court will strike out the action or the case without considering the merit of the case. Jurisdiction is the third factor. What then is jurisdiction? According to the Black's Law Dictionary, jurisdiction was defined as a court power to decide or issue a decree. The power of the court to decide or issue a decree. Jurisdiction is very fundamental, that is one point we should note, that jurisdiction is very fundamental. What then are the ingredients of jurisdiction? In the case of Madukolu and Nkem Dilim, the following are the tests or the ingredients for jurisdiction. Number one, that the court is properly constituted both in number and qualification. Two, that the subject matter is within the court's jurisdiction. And three, that the action is instituted by due process of law. Jurisdiction can be substantive or procedural. One point we should take home is that substantive jurisdiction can be raised at any time, even on appeal. Number four, the fourth factor is limitation period. What is limitation period? We should note that limitation period is the period of time within which an action can be filed from when the cause of action arose. For every cause of action, there is a limitation period. For instance, the limitation period for defamation is 3 years, while that of contract under seal is 12 years. We should further take home that once the limitation period has elapsed, the action is statute barred and is already dead. Number five is venue. Venue is the place where the action will be instituted. Where is the place where the action will be instituted? An action on land should be instituted where the land is situate, while an action bordering on contract should be instituted in the judicial division where the contract ought to have been performed, or in the judicial division where the defendant resides or carries on business. Number six is exhaustion of available remedies. One point a claimant must note is that for the claimant to institute an action in court, he must make sure that he has exhausted the available remedies. Else, the action will be deemed to be premature and the court will decline jurisdiction, thus striking out the claim. Number seven is pre-action notice / condition precedents. These are conditions which must be met. Pre-action notice / condition precedents. These are conditions which must be met before the claimant and his counsel can commence the action in court. We should note at this point that some statutes or the statutes establishing statutory corporations in Nigeria, sometimes provide for pre-action notice to be given to such corporation before an action can be commenced against it. For instance, the pre-action notice for the Corporate Affairs Commission, that is CAC, is 30 days, and this can be found in section 17 of the Companies and Allied Matters Act 2020. While the pre-action notice, required pre-action notice for the Nigerian Ports Authority is 1 month and can be found in section 92 subsection 1 of the Nigerian Ports Authority Act. Number 8 is parties. For an action to be commenced in court, the proper parties must be before the court, else the jurisdiction of the court will be challenged. Where the proper parties are not before the court, the jurisdiction of the court will be challenged. Now, we should note that an action against the Nigerian Law School will not see the light of the day because the Nigerian Law School is not a juristic person. Thus, an action cannot be commenced against it. That is the Nigerian Law School. Number 9 is immunity. Number 9 is immunity. We should note that certain persons are protected by law from being sued against by virtue of Section 308 of the Constitution of the Federal Republic of Nigeria. And these categories of persons include the president, the vice president, the governor, and the deputy governor of a state. However, an action can be commenced against them in their official capacity. We should further take home that diplomats, members of their families, their official and domestic staff, and the members of their families are are immune from legal action in Nigeria. This can be found in Section 1 and 10, Section 1 and Section 10 of the Diplomatic Immunity and Privileges Act. We should, however, take home that this does not include their staff who are Nigerians. You can also read up Ishola and British High Commissioner. You can read up the case of Ishola and British High Commissioner. Other preliminary matters to be considered include A. The stamp and seal of the Nigerian Bar Association. B. Cost of litigation. C. Enforceability of judgment. We should note that enforceability of judgment is very important because most judgment against the executive arm of government is very difficult or are very difficult to be enforced. Thank you. I remain Ogunye Briggs.